Thank you all for coming. My name is Thomas Hazlett. I'm a professor of law and economics at George Mason University and a director of the Information Economy Project. And we thank you all for coming out today. Mr. Corn-Revere tells me his speech is a little longer than normal, but you'll all be safely home to see the start of the NC2A Men's Championship game. Robert Corn-Revere is one of the leading authorities on the First Amendment and what it means in the digital era. The issue could not be more timely, as traditional radio and television broadcasting are eclipsed by cable and satellite, the internet-connected PC and the MP3 player, as the New York Times is now distributed not just on paper but via wireless connections to the iPhone or the Kindle, and as the world of physical scarcity in airwaves yields to robust debate amongst cable news networks, what is left of the public trustee concept at the very heart of broadcast licensing? Is the fairness doctrine's rebirth just a 3-2 FCC vote away? Some actually hope so. Mr. Corn-Revere notes that Harvard's Cass Sunstein, now a leading regulatory official in the Obama administration, argues that the fairness doctrine should be reinstated, not just for broadcasting, but for newspapers, a form of convergence that extends rather than preempts state control. Sunstein has written that it will be necessary to abandon or at least qualify the basic principles that have dominated judicial, academic, and popular thinking about speech in the last generation. An unregulated press may, he argues, itself be an abridgment of the free speech right. Between the words of the First Amendment, the performance of traditional regulations such as the Fairness Doctrine, and the emergence of an exciting new world of digital convergence, there lies a vast gulf of policy quagmire. Robert Corn-Revere may be one of the few who is prepared to tackle the challenges that lurk just there. He is a lawyer who spent his formative years as a regulator, working as a legal advisor to longtime FCC member James Quello, and served as chief counsel in 1993 when Mr. Quello was promoted to FCC chair. Leaving the agency for private practice, he is now a partner at Davis Wright Tremaine. He has litigated cases to the U.S. Supreme Court, successfully arguing that the court strike down a section of the 1996 Telecommunications Act in U.S. v. Playboy, and as lead counsel to CBS in CBS versus FCC, the case over Miss Janet Jackson's famous fashion faux pas during halftime at the 2004 Super Bowl. We'll be posting that on our website, actually. Just kidding, Dean. Yeah. Mr. Corn-Revere is an expert and a big thinker about what free speech means in the modern era. We are delighted to host him as part of our ongoing Big Ideas About Information lecture series, and are also delighted to make an important announcement today. Due to a generous grant from our colleague, Gordon Tullock, a colleague here at George Mason University, this series shall henceforth be known as the Tullock Lecture. Gordon, always a big thinker himself, is a wonderful colleague and the perfect benefactor for this event. We at the Information Economy Project are honored to host it. Today, Mr. Corn-Revere will speak for perhaps about 1 hour, and then engage in some Q&A. Please hold your questions until that time. Mr. Corn-Revere, the floor is yours.
Thanks, Tom. It's always a pleasure to get together with Tom Hazlett, and actually I think he pretty much covered everything I was going to say, so if you have any questions now, we can just handle those and then go home. But actually, since I brought my W-9, I guess I should say a few words and talk about the issues. But you did touch on the key term that is going to be the central theme of what I talk about, and that's convergence, and what it means for First Amendment theory and what it means for regulatory agencies like the FCC. What I'm going to try and do in the space of this presentation, and you'll see it's PowerPoint, is just to talk about some of the overarching themes rather than particular proceedings that are going on at the FCC. And in many things it makes sense to start at the beginning, so let's start with 1934, which was a rather pivotal year. The Flash Gordon comic strip appeared for the first time in January of that year. Einstein visited the White House, and public officials were convinced they had the Depression licked because unemployment had reduced to a mere 22%. In the world of communications, a number of other things were going on as well. The Hayes office implemented its system of film censorship that year, but paradoxically, at the same time, Random House published Ulysses in the United States, risking obscenity prosecution. And this was also the year that Congress created the Federal Communications Commission by passing the Communications Act of 1934 and consolidated communications regulation in a single agency. Oh, and there was one other thing. Paul Oakley envisioned the Internet and the World Wide Web. Hadn't heard of that one, had you? Mr. Oakley was a lawyer, a peace activist, and a pioneering information scientist. And in 1934, he published his book, The Treatise on Documentation, or The Book on the Book. And what you'll find in there is sort of a conceptualization of what I think is best to call the rudimentary elements of what would later become the World Wide Web. He described it as the new book, and the key to it was convergence, that you would have all of these different media brought together. You would have celluloid, or represented by this film strip, a phonograph, radio, television, and all of it interconnected by telephone. You would have an interactive system where people could pose questions and get the information back in whichever form made the most sense, whether audio, video, or a combination of the above. You can see his diagrams where he combines the different media together and also connects by telephone the different means of transmission. He called this the new book. He said cinema, phonographs, television would be interconnected by telephone, and these instruments would be taken as substitutes for the book, and they will in fact become the new book. He wanted to bring together the most powerful works for the diffusion of human thought, and this will be the radiated library and the televised book. And you can see what he had in mind here was a networked system of global information. Some of this sounds eerily familiar, doesn't it? This is the Supreme Court describing the World Wide Web when it first had the opportunity to look at what this new medium meant. It described the World Wide Web as both a vast library, including millions of readily available and indexed publications, a sprawling mall offering goods and services. It said that information available on the internet is diverse as human thought, with the capability of providing instant access on topics ranging from the music of Wagner to Balkan politics to AIDS prevention to the Chicago Bulls. Sounds very much like the way Paul Oakley was describing his book on the book in 1934. But of course, this wasn't the only utopian thing that was happening in 1934. I jumped ahead a little bit to talk about the internet just to show that the way new technologies are often envisioned is to describe them in utopian terms. Let's go back and look at this quote from Tesla for a second. Nikola Tesla, who was a pioneer in his own right, competitor to Edison, said that we are on the verge of a gigantic revolution whereby his radio power will be used to transmit movies over long distances. He would have a central control for the control of dirigibles, for airplanes. Okay, well, he didn't quite get that right, although you might wonder what he would make of the standard control tower in any modern airport. But nonetheless, the way in which people talk about the internet today is the way people talked about radio in 1934 when the Communications Act was adopted. This is the cover from a trade publication from a few years earlier. It's radio broadcast from February 1926. And you can see the way in which this new medium was envisioned. It was almost miraculous. You had this God from the sky bringing these wonders to the American people that were going to transform the way people interacted socially, the way they got information, the way they got entertainment, and some theorized at the time they would get light and power as well. Of course, what's a government to do when confronted with a new technology? In 1934, the answer was regulate it, and the idea was to borrow a concept from the 19th century to regulate railroads, the public interest, convenience, and necessity. And even though this new act prohibited censorship on the radio, It also gave the Federal Communications Commission, as Congress had the Federal Radio Commission before it, more power to control speech on that medium. The agency had more or less of a dual obligation. Section 326 of the Act, which had been borrowed from Section 29 of the Radio Act, prohibited censorship. Nothing in this Act shall be understood or construed to give the Commission the power of censorship, and no regulation or condition shall be promulgated or fixed by the Commission, which will interfere with the right of free speech by means of radio communication. Yet at the same time, the agency was given the obligation to license broadcasters, to determine whether or not they had served the public interest based on the programming service they provided, and it also was given the obligation to enforce regulations against obscenity, profanity, and indecency. So it had to find a way to balance these dual obligations, prohibiting censorship on the one hand, but at the same time regulating programming in a way that wasn't permitted for traditional media. They got their cue from the Federal Radio Commission and some of the early cases involving licensing then. First of all, before we go any further, I think the hair alone from this guy was probably the reason why he got his license yanked. But nonetheless, this is fighting Bob Schuller. He was a radio preacher at the time and very popular in Los Angeles. He'd been given his station by a rich widow, and he quickly became the scourge of the corrupt in Los Angeles. He decided to run radio crusades where he would drive corruption out of the city. And he also wasn't all that nice toward other religions as well. He disparaged Catholics and Jews frequently. He also, one story about Bob Schuller is that he would announce that he saw this noted personage coming out of a bordello, and unless they made a contribution to the church the next week, he was going to name them in the following radio broadcast. He got dozens of contributions. Now, I'm told that that story was debunked during his later licensing renewal hearings, but nonetheless, that was the kind of guy that he was. Anyway, because he was the scourge of the corrupt didn't like it very much, and they complained to the FCC, and this was one of the early cases in which the Federal Radio Commission, the FRC, and this was one of the early cases in which the FRC was testing its authority to deny license renewal because of programming. Now, interestingly, this case went on for some time. The hearing in Los Angeles lasted 16 days. It was conducted for the first time by someone who was not an FCC employee, but instead by a prosecutor who had been hounded from office by Bob Schuller. They presented as their main exhibits basically transcripts of what he'd said on the radio, saying that it was harsh and vindictive and intemperate, and it pretty much was. But in any event, the hearing examiner decided to renew the license anyway, but was overruled by the FCC, saying that this was sensationalistic rather than instructive and didn't serve the public interest. Bob Schuller appealed the case to the DC Circuit, arguing that his speech was protected by the First Amendment. And the Federal Radio Commission, in its defense to the court, argued that this wasn't even speech within the meaning of the First Amendment. This was just radio. It's not speech. They also argued that the no censorship provision of the Federal Radio Act is not offended by looking at broadcasts to determine whether or not the public interest is served, or whether or not subsequent punishment or denial of license is a sanction that violates the Constitution. The DC Circuit, in a 1932 decision, upheld the Federal Radio Commission's denial of license renewal. And it didn't go so far as the agency had wanted. It didn't rule that that radio was not speech within the meaning of the First Amendment. But it did simply say that this is merely an instrumentality of commerce, and that license revocation is merely the application of the regulatory power of Congress in a field within the scope of its legislative activity. And then it also parroted the FCC, saying that denial of license renewal of a licensee's intemperate attacks on public officials and for broadcasts that are sensational rather than instructive does not violate the First Amendment. Now, in a way, a decision like that, coming as it did in 1932, is not that remarkable. If you think about the history of the First Amendment, it really wasn't interpreted by the Supreme